Against it.
The Honourable Leanne Dalzell.
Mr Chairman, I would like to add weight to the comments made by my colleague Dennis O'Rourke with respect to the Legal Assistance Sustainability Amendment Bill as it's introduced, but now to be the Legal Assistance Amendment Bill. And the reason that I think the government have taken the word sustainability out of the bill or out of its title is really to take away from our reflections on the legislation its real focus, which is actually about cost cutting. And to use the word sustainability when actually you mean cost cutting, I think is unfortunate. So I certainly approve of the removal of the word sustainability, but I question whether it was put there in the first place for reasons that I think are unhelpful to a public discourse around something that perhaps isn't a very popular subject, which is access to justice. Obviously, there are people who are very easy targets when one is looking for cost-cutting measures, and I think those that face criminal charges in our courts are the very easiest of targets. I want to remind the House why this legislation was introduced in the original format that it was, and again, it wasn't a desire to address the overall issue of sustainability. It was to look to where cuts could be made to legal aid that would be acceptable in terms of that, in terms of the public eye. And I want to remind the House what one risks when one goes down this track, helpfully summarised in the original regulatory impact statement that was prepared for the original legislation. And I do think it's important to place on record when we're dealing with Part 1, because this is the substantive part of the legislation, why these particular, what the particular risks were that were discerned right from the outset. The first one was that a change of purchase approach was required, but is likely to be resisted by some parts of the legal profession, particularly those who may feel that it will reduce their incomes or curb the choices they can make when managing cases. This is likely to lead to an increase in the number of legal challenges of legal aid grants, as well as public concern. And I just want to unpack that language a little bit, because what it's about is about actually blaming the legal profession that devote their lives to supporting people through the criminal courts, particularly those at the lower end of the offending range, who day in, day out in the courts in South Auckland provide a level of service that most of the legal profession that are their colleagues do not have anything to do with and can have no understanding of. My previous colleague, Charles Chabot, and I both met with the South Auckland Bar, and we were incredibly impressed with the commitment and the work that people were prepared to do for clients who don't fit the normal corporate lawyer's waiting room, shall we say. And the examples that they gave us were clients that couldn't keep appointments because they weren't out of bed before 10 o'clock in the morning. They had clients who couldn't communicate easily in English because that wasn't their first language. They talked about clients who were so disoriented and confused and really excluded from wider society because of their drug and alcohol addictions, and by the way that they had been disenfranchised from their communities and from their families, and in many respects found lost in a city that really didn't feel like home. They talked about people who got themselves in trouble very early on, who didn't have good lawyers representing their interests, and who ended up on a trajectory that was a never-ending trajectory to prison. And, Mr. Chairman, they would end up taking on these cases and taking on, and I think as one of my colleagues mentioned, paying the $50 if there was a fee that needed to be paid from the outset just to get them in the ballpark. And the number of times that they told us about the examples of young men in particular, Māori and Pacifica, who pleaded guilty to offences that they weren't guilty of because they didn't know that there was a difference between an action and an intention, and who ended up in a place where they were down this track and potentially now under the three-strike legislation facing very, very serious charges. They talked about the commitment that they made to people that we really would rather that we didn't have to deal with. And the thing is that this legislation was all about making sure that those lawyers didn't get to talk about how it might reduce their incomes or curb the choices they can make when managing cases. I'm sorry, but the regulatory impact statement advice does not match the reality of lawyers working in South Auckland. And then the regulatory impact statement talked about reductions in the price paid to lawyers could create gaps in provision, particularly in the family and civil jurisdictions where there is more choice of private work, and in some smaller centres where there are already supply issues. Well, actually, that's a risk that's already been realised, and we know that. The introduction of income and asset thresholds for the criminal means test, which we know has been addressed, will be in tension with Section 24F of the New Zealand Bill of Rights Act, providing for the right to an affordable defence. It could also delay some court cases if judges defer proceedings because of inadequate representation. I think we must remember these things, that the Bill of Rights Act exists with these protections for a reason. It is about access to justice. It is about people who require adequate representation. Mr. Chairman, restrictions to eligibility will disadvantage people on low incomes who have few options to find legal services elsewhere. Generally, this includes young Māori men in the criminal jurisdiction and women and children in the family jurisdiction. Mr. Chairman, then he goes on to say withdrawing legal aid for low-income groups is likely to lead to additional costs elsewhere in the justice system. In particular, it may increase the number of self-represented litigants, which we heard all the way through the family court cases, with flow-on costs due to delays, additional assistance required from court staff and the judiciary, and higher numbers of appeals of decisions. These were the risks. They were all calculated, they were all assessed, they were all set out in the regulatory impact statement, and the truth is that they are really important risks. And there are things that we don't like to say in this country, but I'm going to say one of them here and now. If you are Māori, you are much more likely to be stopped and questioned. If you are stopped and questioned, you are much more likely, if you are Māori, to be arrested. If you are Māori, you are much more likely, if you are arrested, to be charged. If you are Māori, you are much more likely to be charged with a much more serious offence or number of offences. If you are Māori, you are much more likely to be found guilty, and if you are Māori, you are much more likely to end up in prison. We cannot allow that to continue to happen, and I believe that this piece of legislation is part of a package of measures that continues to perpetuate the problem that we have in this country. It doesn't address the problem, it only perpetuates it, and unfortunately another wasted opportunity to address the real issues that we must confront as a country if we are really to move on and to address things that are important. Mr. Chairman, I want to agree entirely with my colleague Dennis O'Rourke when he talked about the fact that this bill continues to propose that an application for legal assistance may be turned down if the applicant is in arrears in repaying any part of a previous grant of aid that he or she may have received. And I believe this could be the opportunity in the committee stages in the House to actually redress that problem, to actually address that problem, to fix what we have in front of us and to make it good. And that would help us to see this bill passed, but we cannot support it the way that it is drafted.
Mr Chair.
I call David Clendon.
Thank you, Mr Chair.